Hello everyone. Welcome back to our channel US Immigration. We hope you're doing great. Well, in today's video, we will be talking about what happens after you sue the government for your immigration delay. So, to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for upcoming episodes. So, without any further delay, let's jump into the video. When faced with long delays in processing immigration applications, many applicants feel stuck, unsure of how to move their cases forward. In some cases, the delay can be so significant that applicants may consider filing a lawsuit against the U.S. government. Whether you are dealing with a delayed immigrant visa, green card, asylum, or naturalization case, the process can be frustrating and stressful. Filing a lawsuit, particularly a mandamus action, can sometimes prompt action on the case, but the process that follows can be daunting. In this video, we will explore what happens after you sue the U.S. Citizenship and Immigration Services USCIS or the U.S. Department of State for an immigration delay. Understanding the lawsuit, Mandamus Actions. The most common type of lawsuit filed in immigration delay cases is a mandamus action. A mandamus is a court order that compels a government agency to perform a duty that it is legally obligated to complete. In the context of immigration, this typically means that the applicant is asking the court to order USCIS or the Department of State to make a decision on their application, whether it be for an immigrant visa, green card, citizenship, or asylum. It's important to understand that a mandamus lawsuit does not guarantee that the decision will be favorable. It simply forces the government to act, whether that results in an approval or denial of the application. When an applicant chooses to sue the U.S. government for an immigration delay, it is often a last resort after other avenues for resolving the delay have been exhausted. Filing the lawsuit, the initial steps. Once you decide to file a lawsuit against USCIS or the State Department, your attorney will file the case in federal court. While the idea of going to federal court may sound intimidating, it's important to note that the vast majority of these cases are handled on paper, and the applicant rarely has to appear in court. The lawsuit itself will include details about your case, the length of the delay, and the relief being requested, that is, for the government to make a decision. Once the lawsuit is filed, a copy of the complaint is sent to the defendant, which is typically USCIS or the Department of State. The government then has a legal obligation to respond to the lawsuit. What happens after filing? After the lawsuit is filed and the government is served with the complaint, there is a specific timeline that follows. The government usually has 60 days to respond to the lawsuit, although this can vary slightly depending on the nature of the case. During this period, a few different things might happen. 1. Government begins working on your case. In many cases, filing a lawsuit prompts the government to start working on the immigration case that had been delayed. Once the government receives the lawsuit, they know that they are under pressure to act within the 60-day window. This often leads to USCIS or the State Department taking immediate steps to move the case forward. In some instances, the agency might have just been sitting on the case and needed a nudge to act. Some immigration offices are particularly responsive to lawsuits. In certain regions, like Texas, Chicago, Baltimore, and California, offices have been sued frequently enough that they know how to handle these cases swiftly. They understand that deciding the case quickly can make the lawsuit go away, and they will often expedite the next step in the process, such as scheduling an interview or requesting additional evidence. 2. Interview requests. Once the lawsuit is filed, applicants might find themselves scheduled for an interview, whether it's their first interview or a follow-up. This can happen fairly quickly after the lawsuit is served. For example, if the delay involved a green card or citizenship application, USCIS may schedule the applicant for their final interview. If it's an immigrant visa case stuck at a U.S. consulate abroad, the consulate may request the applicant to attend an interview. In some cases, the government may ask for more time to complete the interview process, which is a good sign that the case is progressing. Attorneys can work with the government to extend the timeline slightly if necessary to avoid further delays. The goal is to move the case forward efficiently, without the need for a drawn-out legal battle. 3. Requests for evidence. If the government needs more information to decide the case, they may issue a request for evidence RFE. This could happen at any stage after the lawsuit is filed. RFEs are common in cases where USCIS or the State Department needs updated documents, additional verification, or further clarification on specific aspects of the application. For example, in marriage-based green card cases, the government might request additional proof that the marriage is legitimate. In asylum cases, they might ask for updated country conditions or more details about the applicant's fear of persecution. While receiving an RFE may feel frustrating, it is often a sign that the case is moving forward and nearing a decision. Possible scenarios after filing the lawsuit. Now that we've covered the basic steps following the filing of a lawsuit, let's explore the various scenarios that might unfold once the government begins working on the case. Each case is unique, and the timeline can vary depending on the type of application, the specific office handling the case, and the circumstances surrounding the delay. Below are some of the most common outcomes. 1. Case approved. In the best-case scenario, the lawsuit acts as a catalyst for approval. The government might have been ready to approve the application but simply had not done so due to administrative delays. Once the lawsuit is filed, the agency might fast-track the approval process, and the applicant will receive the final decision whether it's a visa, green card, asylum grant, or citizenship approval. 2. Case denied. While less common, it is possible that the lawsuit will result in a denial of the application. This could happen if there are unresolved issues with the case that the government finds problematic after reviewing it in response to the lawsuit. For example, if USCIS or the State Department uncovers information that disqualifies the applicant, they may choose to deny the case rather than approve it. In these situations, the lawsuit has still achieved its purpose, forcing the government to make a decision. 3. Additional interviews or investigations. In some cases, filing a lawsuit will prompt the government to conduct additional interviews or even home visits. For example, in marriage-based green card cases, USCIS might conduct a Stokes interview, where the applicant and their spouse are interviewed separately to assess the authenticity of the marriage. There are also instances where USCIS officers will conduct home visits to verify that the marriage is genuine. While this may seem intrusive, it is part of the government's process to ensure that the case meets all legal requirements. These additional interviews or investigations are generally a sign that the case is progressing toward a final decision. 4. Requests for updated medical exams or background checks. If the delay in the case has been lengthy, the government may request that the applicant undergo an updated medical exam or background check. This is particularly common in cases involving immigrant visas or green cards, where medical exams and background checks must be current at the time of approval. For consular cases, the embassy may request that the applicant provide updated documentation, such as a new DS-5535 form which collects additional information for background checks. This step is typically part of the final review process before the case is approved. We're working with the government after filing. One of the key aspects of filing a lawsuit is maintaining open communication with the government. While a lawsuit might sound adversarial, immigration attorneys often work closely with government attorneys to move the case forward as smoothly as possible. In many instances, the government attorney assigned to the case will reach out to the applicant's attorney to discuss the next steps. This could involve scheduling interviews, requesting additional information, or negotiating a brief extension to allow the government more time to make a decision. The goal of both parties is often to resolve the case without prolonged litigation. The lawsuit is not meant to create conflict, but rather to prompt action. By working cooperatively with the government, the process can often be expedited without the need for a trial or further court appearances. Timeline and expectations. It's natural for applicants to wonder how long the process will take after filing a lawsuit. While there is no set timeline, most cases see significant movement within the first 60 to 90 days after the lawsuit is filed. However, some cases may take longer if there are complications, such as requests for additional evidence or interviews. In rare cases, if the government fails to take action within a reasonable time frame, the court may schedule a hearing to determine why the delay persists. However, as mentioned earlier, most cases are resolved before this happens. The vast majority of lawsuits filed for immigration delays do not result in court appearances or trials. Instead, they serve as a mechanism to push the government to make a decision. Final thoughts: should you sue USCIS or the State Department? Filing a lawsuit against USCIS or the State Department is not a decision to be made lightly. It requires careful consideration and consultation with an experienced immigration attorney. However, for many applicants facing unreasonable delays, a mandamus lawsuit can be an effective way to move their case forward. It's important to remember that the goal of the lawsuit is not to antagonize the government, but to ensure that your case is given the attention it deserves. Whether you are waiting for a visa, green card, citizenship, or asylum decision, a lawsuit can help break the logjam and lead to a final resolution. If you are considering filing a lawsuit for an immigration delay, be sure to consult with a knowledgeable immigration attorney who can guide you through the process and help you achieve the best possible outcome. The key takeaway is that while delays can be frustrating, legal action can often provide the push needed to move your case forward. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video.
Hello everyone, welcome back to channel US Immigration. We hope you're doing great. Well, in today's video, we'll be talking about what happens after you sue the government for your immigration delay. When faced with long immigration delays, applicants may consider suing the US government, typically through a Mandamus action. This lawsuit compels the government to make a decision on an application for a visa, green card, asylum, or naturalization, though it doesn't guarantee a favorable outcome. A Mandamus lawsuit is often a last resort when all other options to resolve delays have failed. Once the lawsuit is filed in federal court, a copy is sent to the USCIS or the US Department of State, the government usually has 60 days to respond. Filing the lawsuit often triggers immediate action on the delayed case, such as scheduling interviews or requesting additional information. Some offices, especially those frequently sued, are responsive and expedite the case to avoid prolonged litigation. Several scenarios can unfold after the filing the lawsuit. In the best case, the government may approve the application. However, the lawsuit can also result in a denial if the government finds disqualifying issues. Additionally, the government might request more interviews or conduct investigation, such as home visits and marriage-based green card cases. Requests for updated documents, medical exams, or background checks are also common in cases involving significant delays. While filing a lawsuit might sound confrontational, the process usually involves collaboration between immigration attorneys and government attorneys to resolve the case without prolonged court proceedings. While filing a lawsuit might sound confrontational, the process usually involves collaboration between immigration attorneys and government attorneys to resolve the case without prolonged court proceedings. Most cases move forward within 60 to 90 days, although complicated cases may take longer. Ultimately, suing USCIS or the State of Department is a serious decision that should be made with the guidance of an experienced immigration attorney. A lawsuit can be an effective way to prompt the government to take action on an application, especially for applicants experiencing unreasonable delays.